All right, well, good afternoon, everyone. My name is Molly Ross. I'm the Vice President of Operations at the Technology Association of Iowa. Thrilled to have you all with us here today for our webinar on data privacy and the Iowa model. Before I introduce my colleagues, just a couple of really quick housekeeping notes. You can probably see as attendees, your microphones and cameras are turned off. That does not mean we don't want to hear from you. We have lots of time planned at the end for questions. As you do have questions throughout, please go ahead and drop them in the Q&A button you should see at the bottom, and we'll make sure we get to those before we wrap up today. Also, this webinar is being recorded, so should you want to revisit it or share it later, it will be on our website here in the next few days. So before I introduce my colleagues, I also want to set the table just a little bit. I know we have some people with us who may be new to the Technology Association of Iowa. We are a member-based trade association serving over 350 member companies across the state of Iowa. We believe every company is a technology company, and that technology is the driving force behind just about every industry and company today. And I think today's conversation is going to highlight just that and how integral technology is in moving us forward. The journey to establishing Iowa's consumer data privacy law has been a couple of years in the making and has been an effort with my colleagues that are with us here today, as well as about 50 other organizations from across the state. We are going to take a look at that process today, talk a little bit about what that law, what it means for companies, and how you can move forward. So with that, I am excited to introduce my colleagues here today. I have with me Tim Coonan, Government Relations Special Counsel at Denton Davis Brown and TAI's Legislative Liaison, as well as Aaron Warner, CEO of ProCircular and the chair of TAI's Public Policy Committee for the last couple of years. Tim, you want to get us started?
Sure, that'd be great. Moderator, panelists, here we go. That's okay. Thank you everybody for calling in this afternoon. We're here. I'm at the Iowa State House as they're trying to wrap up this legislative session. This legislation will go down in history as one that accomplished a lot. One of the major accomplishments will be the Iowa model, the Consumer Data Privacy Act. We are the 6th state in the country to do it. I would say that you can go to the next slide if you want. I would say that this is generally what it does. Governor signed this into law back in late March. And just a little bit about how we got here. You know, the data privacy regulatory schemes and structures really started in Europe. First time we saw it was here in the United States, was in California. As is with much regulatory scheme in California, they come down hard. The next stop was Colorado, then Vermont, another couple of laws based off of California with a lot of the same components, and then Virginia. Virginia was really the first example of where consumers and industry were at the table and put together what I would say is a much more workable data privacy from a compliance perspective. And that's something Aaron Warner is going to get into a little later. Utah then came after Virginia, which was last year, and modified it further. Many of the same components of Virginia were in Utah. And then Iowa, 2 years ago, TAI made this data privacy law its top legislative priority. And last year, we tried and did not get to the finish line. Our members redoubled their efforts, education efforts with legislators. We also saw the advent here in Iowa of a technology committee, a standing technology committee in the Senate, and a standing technology committee in the House. Almost right in time, because technology bills just started flooding the legislature. This was the backdrop for that. So, and we can move ahead to the next slide. Here we are now, and who's impacted? Again, these are pretty common terms. The idea is we really can't wait for Congress to act on data privacy. but companies who are operating in multiple states need some level of certainty and some level of uniformity in order just to be able to comply and understand what their requirements and rules are state by state. So you'll see this language in the other states. And that's who this law applies to. Next slide.
Tim,
Yeah.
just a little context there. I'm actually dialing in from the other place. I'm still in DC. We just spent, the Technology Association of Iowa just spent the last week speaking with, I think for the most part, all of Iowa's legislators, be they congressmen, congresspeople or senators. Having done this, having chaired that committee for a couple of years now, people tend to run hot or cold on these topics, but I think consistently the experience that Molly and I and the group from TAI had was that they welcomed this with open arms. I think it's important, and you touched on this. A lot of what's written into this privacy policy is in lieu of an overarching federal piece of legislation. I think that everyone in industry that you talk to, whether you're talking about data privacy, whether you're talking about disclosure law, whether you're talking about any of the overarching things from a regulatory or compliance perspective, it would be easier to have one rather than 52 different versions. But given the political realities in DC right now, and given, frankly, the complexity of these topics, it's proven difficult to get federal legislation moved through. That said, and I won't name names, but several of the discussions that we had over the course of the week were from Iowa legislators who are interested and have already started to work with Iowa House legislators to help to promote this Iowa model so that it is actually applied at a federal level. So I think some of the work that we've got coming up as an association, and it's an area where members have kind of a unique opportunity to participate, we may have a chance to help craft the federal legislation for data privacy. So that is a very big deal for everyone involved. Certainly anybody who bothered to call into this would be affected by that. So just a little context from the last week or so, I think we found, regardless of political stripes, regardless of where they're coming from, the legislators in Iowa see the value of protecting Iowa citizens and the citizens' privacy, and they see the importance of this legislation. They're moving forward with it pretty quickly. So I was really excited. This last week was great.
No, I appreciate that context, Aaron, and I think as evidenced by the overwhelming majorities that voted for this bill in both chambers here in Iowa, the bipartisan support for it. One of the questions that initially came up was, is this strong enough? And the answer was, well, we don't have any data privacy protections now. Anything we do will be stronger, which indicates to me and to you and to anybody on this call, one, there is a appetite for it. So it is in our best interest to work collaboratively with consumer groups and industry to come up with a workable solution. But the second takeaway is this is not the last bite at the apple. This is going to be a code section once it takes effect in 2025. I would expect we're going to be tweaking and changing and evaluating and reviewing on every legislative session. The idea, as Aaron alluded to, would obviously have something consistent in all the states enough that it's not patchwork, and that if the federal government were to act, they'd be able to take what has happened in the states and make it a seamless transition. I know that's a pipe dream, but I think, I would expect if your company is doing business in other states, expect this conversation to happen in other states. And I can tell you that in Iowa, we pulled together a coalition of quite a few different groups, and they weren't just from Iowa. There were trade associations from out of state who have members in Iowa, who do business in Iowa, that wanted to make sure they had some hand in getting it done. And so, it was definitely a collaborative effort, and one that I think can be replicated in other states. Molly, next slide, please. Okay, so who is impacted, who isn't impacted? So one of the other key pieces of this legislation, which is also the same or similar in other states, is that industries that are already subject to a comprehensive privacy law we wanted to incorporate them by reference rather than reinvent the wheel. The financial industry already covered by Graham Leach Bliley. Healthcare industry covered by HIPAA. Education industry, or not industry, but the education field covered by FERPA. The Child Online Privacy Protection Rule triggered a particularly interesting question, because I don't think anybody understood that COPPA, which happened nearly at the dawn of the internet, that was available broadly, contemplates 13 years old and not 18 years old as protections, providing up to 13 years old. We incorporated that into the Iowa law, but I can tell you that conversation spurned a conversation that continues here this last day of session, where legislators are talking about separate legislation that would limit access to social media for people under 18. And so, like I said, we didn't want to reinvent the wheel, and we incorporated all of those statutes by reference, and also exempted these other entities that are similarly covered by data privacy rules and regulations.
Well, and Tim, one of the things, and I think this is later in the presentation as well, but we are seeing just from a strategic perspective, we're seeing a deluge of regulatory responsibilities and industry-driven responsibilities, as well as those coming in from cybersecurity insurance. So that is a lot to manage. The good news is that a lot of the fundamental tenets of each of these bills, or each of these sets of regulatory responsibilities, are the same. And at a minimum, you can use the same set of tools to track your progress across these various sets of obligations. So it looks pretty daunting, but if you take a smart approach to this, you can actually take some of the sting out of it.
Agreed. Okay, next slide, please.
So this was one of the examples of a specific set of areas within not only this, but you'll see similar sections in CCPA. You'll see similar sections in GDPR. So this is where the rubber sort of hits the road. So if a consumer that fits within this definition reaches out to your organization, and they have the right to request any of these things, confirming the processing of the consumer's data. So are you using my data? If I'm, for whatever reason, unhappy with your organization, or I just don't like my personal data being used by your organization, I have the right to request deletion of those personal data. I'll get back to that in a second. You have the right to request that your own personal information. So you could theoretically reach out to one of the social media platforms and say, hey, I would really like to see what information you have on me. And they have a responsibility to reply to that. And of course, you also have the ability to opt out of the sale of personal information. We could probably do an hour-long webinar on each of these 4 items. The one that I wanted to hit kind of underlines the complexity of not only the regulation itself, but the mechanics of having to delete this. It's one thing to ask an organization for deletion of personal data if it's simply a website, like we'll say the TAI website. It has all that information in one place, it's protected, and it's a relatively straightforward thing to delete those personal data. If you ask a larger organization, and again, I won't name names, but let's say one of the larger companies in the state of Iowa with 50,000 plus employees, the sheer number of systems that those organizations have make this a rather daunting step. And on top of that, and I'm channeling a colleague of mine, Jim Sherlock, who was with Pearson, there is risk to even having this big red button that allows you to delete data. So this is a part of this bill that I think is going to take some years and quite a bit of coordination for organizations to get their arms around. But as of 2025, if I'm not mistaken, Bill, that Tim, that's the date. Organizations will need to be able to, organizations that fit within this legislation will need to be able to meet these requests. Next slide, Molly. I included this. This is an example. This is from CCPA, but that's probably one of the more recent examples of a response. So this is a response from an auto dealership responding to an individual who has asked for them to delete personal information. So the organizations that fit within this legislation are going to need to develop processes to produce this sort of response when a consumer requests information that to be deleted. This is one of about 6 pages in this particular template, but I thought it was helpful just to get a look at the sorts of things in practice that we're going to have the ability to send to consumers and to send to customers. Next slide, please. Privacy notice is another one. The controllers must provide consumers with a privacy notice, and there's a variety of these of different areas. You've probably seen examples of this on just about every website since the beginning of the year. The privacy notice itself and the piece that and maybe Tim has more to offer on the specifics of the enforcement of this, but the privacy notice itself is one of the places that external organizations can look to determine whether or not you're an organization they want to investigate. It's a fairly visible part of your overall compliance program. So I guess the advice that I would offer here is that this is an easy thing to assume that you can just go to one of these template generators online, generate a privacy notice, and then post it. Unfortunately, this is an area, particularly for larger organizations, where enforcement tends to start. So being careful with that privacy notice and making sure that that's written carefully and properly, not just some template that you downloaded, is a really good way of staying in the good graces of, in this case, the AG's office and the enforcement bodies that are going to follow up. Next slide. And most privacy policy sections include this kind of information, explaining what kind of data that you're collecting, how you're storing those data, data storage and security, so the methods that you're using to secure the data that you do keep, opt-out procedures so that organizations that don't want those data included can pull out, and the company contact information. As I said before, this is a part that you definitely want to get right. How you describe the privacy policy is sort of put your best foot forward in terms of external third parties trying to gauge how seriously your organization takes these obligations. Anything else to add there, Tim?
Yeah, real quick. I would say something that was noteworthy was the natural curiosity on the part of policymakers here to really dig in and understand, because you know what, I think everybody clicks on the cookies. Right, everybody clicks on, do you accept? Do you accept? And everybody reflexively does it because it's just they want to get to the content, right? And that conversation had to be flushed out because people needed to understand what that meant when they were consenting to the collection. That doesn't mean that now the company is exempt from this later after 2025. But it also it triggered a lot of side conversations, and I think it triggered other legislation. I think the other thing to note here is that companies and the Attorney General's office and others were able to weigh in and really have a conversation on what makes sense. You know, there was a conversation about how to collect and what to collect, and there was a really good, robust discussion amongst policymakers, and they were taking into account, I would say, the controllers and the processors position, saying you really, and there was a trust that was developing, which was good. You really don't want to do it that way. You want to do it this way, because if you ask that question, you're not going to get the answer you want. And so that, I think, must have played out the same way in the other states too, because we are largely adopting language from Utah and Virginia. I mean, it's large. You'll find large swaths of Utah and Virginia in Iowa, with just a few exceptions, tailoring it to some of the specific concerns of Iowa legislators.
Tim, I think maybe one last piece in practice around this privacy policy section, if you're thinking about the data types collected, ProCircular is a cybersecurity firm. So we do offensive security work, which often means that we're crawling around in the computer systems of banks and hospitals and very highly regulated organizations. One of the fundamental pieces of our approach to data collection is to not collect it So every piece of data that you have the possibility to collect, you need to ask yourself whether or not you absolutely have to have that information. Do I need to know this person's age? Do I need to know this person's sex or that their full birth date? If you don't need those data, it's best not to collect them because, and frankly, our organization is allergic to PHI. Anything that looks like a medical record in ProCircular's computer environment, we have all sorts of systems that absolutely lose their minds to make sure that we don't end up collecting medical data from the clients that we serve. So I think a really good rule of thumb here is for every piece of data that you have, to the degree that you have the ability, you should ask yourself, do I really need to collect this information from this customer, or is this just ancillary data that we might use down the road? If you're going to use it down the road, probably don't collect it now.
And we have a chance here too, if you're on this call and you are part of the industry or processor or controller, to develop a good reputation in Iowa. You know, we have a runway here for about 2 years before the law becomes effective, where, you know, we can be thinking about tailoring policies and procedures to match this law, because chances are the laws that continue to pass, and I think they will continue to pass around the states, are going to be substantially similar to this one. And so I think the time would be now to start being able to get known by the Attorney General's office, which we'll get into enforcement at the end, as a good actor, get known to policymakers as a good actor. That's only going to be able to help your chances here.
I included just another example. This is another privacy policy template. Please don't use this, and please make sure that whatever privacy policy you generate is one that you actually read and you don't just use some generator to produce, because this is where, I mean, very possibly you could end up in a situation where a consumer makes a request you don't even know that you need to answer. And the AG's office says, well, this is what your privacy policy says. And I don't see that you're doing that. That's a place to get yourself in trouble. So to Tim's point, developing those relationships early, developing relationships with organizations that can help you with the ebb and flow of enforcement, but also really develop this policy so that you know what's in it. Don't just generate a piece of paper that you can send out, because this stuff is going to get important. And again, we keep referring to the enforcement section, but I think that's a big piece of it. Next slide, please.
Sorry about that. This is, as I was alluding to earlier, and as was Aaron, is the enforcement piece. Now I'm going to skip to that last bullet, because I think that's the most important bullet, that no private right of action is allowed. This statute does not create the ability for a private actor to sue a company. The exclusive authority to act under this code section is vested with the Attorney General's office. So one of the things I think that made sense to the stakeholders involved was to not have this tee companies up for major litigation by creating this code section, but rather house it in an enforcement, in an agency accustomed to enforcement. And the Attorney General's office was part of that conversation. And interestingly enough, if you're following Iowa politics, we had two different attorneys general offices collaborating with us, given the year. Last year in 2022, it was Attorney General Tom Miller, longtime Democrat attorney general, and his staff, and they were with us throughout the whole process. 2022 election happens. Brenna Bird, Republican Attorney General, new staff, new legislative liaison, same outcome. And so I think that speaks to the nonpartisan or bipartisan, however you want to put it, way we went about and way this law developed and is now a statute. If you look at the violations, and there are details on how you get there, $7,500 fine for each violation. Now, there is a protocol in the bill, in the law, that it takes a while to get to that fining stage. They have to give you, the Attorney General has to give you notice. You have time to cure. There's a conversation that develops between the Attorney General's office and the controller before it gets to the, okay, now we're going to fine you $7,500. The reason for that was a great conversation. Sometimes it's inadvertent. Sometimes it's a lack of understanding. Sometimes it's an individual who's working at that company that isn't following policy. Those things are all things that the Attorney General's office really wants companies to not feel like they're under the gun, but instead cooperative. Because a company can say, oh, here's what rather than turn it into a lawyer up situation and go dark. It gives you a chance, almost not amnesty, but like I said, sort of a time for cure before it gets into a situation where a company's getting fined. And I mean, $7,500 for some of these huge processors doesn't sound like a lot, but as Aaron reminded me, the scale of data we're talking about, one big slip that could get to be a big number. And I think there's another example of where the industry was willing to have teeth in the legislation. That a lot of times, the criticism when you have legislation that comes out of an industry or specifically focuses on a particular industry, that they're trying to set up a protocol that is easy and is, something that it doesn't have any teeth. Well, this, I think everyone can agree that ends up being teeth. And then you see where the money is collected stay right in the AG's office into a consumer education and litigation fund. Over the next 2 years, our Attorney General's office is going to be doing a lot of work trying to set all this up, set up a consumer education litigation fund, hire people who understand, what they're looking at. And so I move on to when will it go into effect? It goes into effect in a couple of years, and that was typical of the other states as well. And the reason for that is we just made new law. These are new code sections, and there needs to be time for the regulators and time for the processors and controllers to understand exactly what are the rules of the road in Iowa. It also gives us a chance in Iowa to watch as Virginia implements its law and Utah just implemented its law. Since they're all substantially similar, when they run into some unintended consequences, which happens with virtually every piece of legislation that becomes law, we're able to adjust before it becomes effective. And so there's a lot of thought put into that. You don't see a lot of laws passed with an effective date bump that far out. In Iowa, the usual effective date is July 1 of the year the legislation passed, or maybe 6 months later to give an agency time to put together rules. So that was very intentional. And then finally, important to note that this preempts all other Iowa laws and regulations governing the processing of personal data by controllers and processors. There again, wanted to give a very definitive set of rules of the road for companies to understand who aren't otherwise covered by some of those federal statutes that we discussed earlier. Aaron, do you have anything to add to that?
No, I think you hit it, Tim. The thing that I recall from back in the day, I was a chief information officer and I had global responsibility for regulatory compliance. When you look at it from that perspective and you're in a company that's in 50 different countries, or in this case, 52 different jurisdictions, that enforcement piece and everything can't be the top priority all the time, right? It is a difficult way to run an organization. So when comparing what parts of regulatory responsibilities an organization has, the enforcement piece of it is an important variable. I remember in Australia back, this is probably 15 years ago, they had some of the highest, the bar was set very, very high from a privacy perspective, and the violations were fairly extreme in terms of the cost. If you were caught violating those agreements, it could be a really bad day for your organization. The catch was that unlike Europe, where in GDPR, they have The EU has hundreds of people working in enforcement. In Australia, there were zero. They had this really large regulatory set of responsibilities, and they had zero people who would come after you for it. So weighing the realities of a program like this with the responsibilities and frankly the costs and risk associated with them is part of the program. Understanding the enforcement is one of the first keys to that. But I think it is worth mentioning that in Europe, they are enforcing some of these, particularly the GDPR. I don't know that they have gotten quite as aggressive with things like CCPA, and it's too early to tell in Virginia, Utah, places like that. But that is something that a lot of us are going to be watching to make sure that we can temper temper the advice that we're giving to make sure that people are responding according to what the enforcement can actually mean to their organization. What's the likelihood it's going to happen?
And I also think too, for those of you who are not, and maybe you all or many of you are on this call, familiar with Iowa's footprint or the footprint of the technology industry in Iowa, it is way, way outside of the size of the state, given the major investments by some of the major platforms who are also members of TAI. We also have an extremely robust manufacturing industry here in Iowa, I think one of the largest per capita, which are all becoming technology companies, whether they like it or not. And so we had stakeholders here who, from the major platforms you would know, who were intimately involved in the dealings of this. And there was a question about whether having data privacy law would help or hurt attracting companies to the state. And almost overwhelmingly, we heard it would help attract companies to the state or do business in the state because you have a set rules of the road. This is very clear how it's going to be. And if you're looking over the horizon, expect these to be roughly the rules of the road, as it spreads across the country. And then ideally someday, the federal government, the Congress acts. Molly and I had this conversation a number of times because our National Trade Association is actively pushing for federal law. We had questions about whether pushing for state law runs counter to pushing for federal law. And we agreed, no, we are setting the table for federal law and trying to show maybe some incubators as to what works, what doesn't work, so that when and if the federal government does act, those who have been complying or have to comply, those who are being protected, understand their rights and responsibilities, regardless of whether it's happening at the state or the federal level.
One of the pieces of advice, I guess, I also wanted to give here, this can all be really daunting. We're talking hundreds of pages of regulations to read. You're going to need a number of different kinds of advice in order to manage this. But again, where the rubber hits the road, a risk management program is really the way to address this. Many of the larger organizations or organizations that have pre-existing obligations, be they GLBA or HIPAA or FERPA or COPPA, probably have gone down this road. But for organizations that haven't, this is the sort of top level example of a risk register. So you go through a risk management program. It's an iterative and ongoing process. So it's not a thing that has just a beginning and an end. It's a living program within your organization. You take a proactive approach to risks as opposed to just having to deal with problems as they come along. It really promotes, when it's done right, it really promotes awareness throughout the organization. You have to ask a lot of big questions, and the process of doing that brings people's attention to those risks that are the thing that is actually going to get the organization in trouble. So in many cases, you have sort of an idea of these are the things that everybody else has problems with. But when you get into a room and close the door and you say to the head of HR, all right, let's fast forward to the part where we talk about the thing that keeps you up at night. What is the thing that really has you most worried? That's where you start to really get to the good stuff. And the process of doing that really promotes risk consideration. So that HR professional, the next time that he or she has a challenge in front of them, they think, I wonder how this fits into that risk program. And is this a new thing that I need to include so that we can prioritize that risk through the rest of the organization? So you can see some of the headings in here. We like to talk about probability. What's the likelihood that this thing is going to happen? And impact. If this thing does happen, what's the impact on the organization? So, the examples that people use there are if a satellite were to fall out of the sky and hit your building, well, that is a probably fairly low probability that that's going to happen, but it would have a very high impact if it did. The probability is so low that you would probably put that overall priority low as well. That's not a thing we're going to keep ourselves up at night. Whereas if you're an organization that processes credit cards, and that the probability of fraud is high, and that the impact of that fraud is moderate to high, that's a thing that's going to need to come up your risk register a little bit, the thing you're going to need to address first. So in a very similar approach, there are going to be items within your risk register that fall on this legislation. This is one of the best methods for tracking those obligations and making sure that you're really hitting the important pieces of your program, as opposed to just playing whack-a-mole and chasing around whatever new things somebody's turned up this week. Tim?
I think that's great. And I think that, again, highlights why the late effective date. This table right here, Aaron can talk through this in 3 or 4 minutes. This is obviously a lot more than 3 or 4 minutes of work for your organization if you're a controller or a processor. And that time was bought for you in the legislation to make sure you can undertake this or some similar process if you need to, if you already haven't.
We've done this with hundreds of organizations at ProCircular, and this isn't an ad. The only reason that I say that is that once you get this all together, lights really start to come on. You find we've been thinking about this thing when that thing is the major risk. It's a really easy way to save some money on a compliance program. But perhaps most importantly, it's the way to make sure that you're focusing on the highest probability and highest impact parts of your security program. If from an enforcement perspective, some of these, if your organization does possess large quantities of sensitive data, that's going to move that part of this project of your risk management program up the priority list. It's a very high probability and very high impact. So thank you. I just wanted to include this piece. It looks pretty dry, but in conversation, this is really where you find the good stuff for your organization. You can show really great progress. And by the way, cybersecurity insurance in many cases is going to ask for you to demonstrate that you have a copy of this risk register. So this too is no longer going to be thou shall, it will be thou shalt. Like you have no choice in the matter if you want cyber insurance. So this is going to be a part of ongoing life in 2023 and beyond when it comes to cybersecurity and risk management. So next slide, Molly. Tim, since you're the attorney on the call, I thought I would allow you to deliver the good news for this presentation. You don't always get to do that, right?
No, I appreciate that, Aaron, but that also reminds me, I am an attorney. I'm not giving legal advice on this webinar. So just to be clear, but yes, this is good news because this is one of these areas where I feel like the industry and the consumer groups and people are engaged before we let it get away from us. Obviously a lot of track's been laid down with data privacy and breaches and this whole area of regulation and law, but this is going to continue to morph and change. But time is on our side right now. There is time for implementation. As Aaron said, there are resources available. I'm optimistic about other states, given how TAI quarterbacked this data privacy law in Iowa. I think that this is a trend, not an anomaly. And I'm I'm optimistic that it's just going to keep getting better and smarter and more targeted and more to the point that it's fairly perfunctory. And that's the idea, because, you know, to be clear, there's always this healthy suspicion of people in the industry thinking that they're putting together a regulatory or legal structure that benefits them. All of what we do is based on trust. And if a consumer doesn't trust your platform, doesn't trust your product, doesn't feel like they can put their credit card on your website, doesn't feel like they can register their child for soccer, doesn't feel the amount of things that we are asking people to put on the platforms, all predicated on whether they trust that we are being good stewards of their information, and the consumer is getting more educated. And as this younger generation who was born with all of this, I mean, you know, the internet came to my college at Drake University. My senior year is when the internet came to Drake, 1996. That's how old I am. The follow-on generations get better and smarter and more savvy. We need to make sure, like with every area of the law, that the law and regulations are keeping up with the people and the practice and the culture.
Well, and not, Tim, I couldn't agree more, not to emphasize this, but you mentioned this at the beginning of the call. I think it's true here as well. We have an opportunity to participate in the creation of this, right? This isn't some piece of legislation that's happening in some conference room in DC. This is a thing that we're talking about at the TAI office or in conference rooms in Des Moines. And every member of Technology Association of Iowa has an opportunity to participate. Every member on this call has an opportunity to participate and help to shape this legislation. So this isn't something that's just going to get foisted on us. It's an opportunity for us to help shape the kind of legislation that we want. And when I took the legislative chair role a couple of years ago, that was one of, I think, the primary goal was to make sure that we, TAI, had a seat at that table. And I think regardless of party, regardless of whether it's the House or the Senate, frankly, at this point, whether it's state or federal, we have those relationships now, and those folks are very comfortable reaching out to us to say, hey, what do you think about this? What do you think about that? So, Tim, to your point, we have the trust of our legislators here as well. So we have an opportunity to help to shape this, to make it look the way that we want to, as opposed to just being on the receiving end of something like GDPR that we had no hand in creating.
All right, thanks for that, gentlemen. I know we've had a couple of questions come in. Let me pull those up. A couple are a little bit related, but Christian asked, what if you're a service provider for a controller who only sends data that is subject to exceptions such as HIPAA or GLBA? Can't hear you yet.
There we go. That's a good question. Then this law doesn't apply to that piece of what you're doing. I'd have to understand better exactly what we're speaking of. But if you are covered by one of the statutes that's incorporated by reference, then you are in compliance with the statute. That's the idea, is we didn't want to layer on state regulation on top of existing federal regulation.
That was one of the first requests to come in, actually from some of the larger data providers. They wanted to make sure that if they already had obligations and they were following them, that this wouldn't be some new thing on top of it. So, and I'd encourage that we can get a copy of the legislation out. The section that calls out pre-existing regulatory obligations is actually fairly well put together and pretty easy to read from as far as regulatory paperwork is concerned. So I'd encourage everyone to jump in there and see if what the obligations they're already meeting are already covered. We had input from all kinds of different people on other standards, things like COPPA and HIPAA that people wanted to carve out. So yeah, that's a great question. Molly, what else do we have?
Somewhat related here, I think. We had a question. In a non-covered industry, what have you seen regarding companies that are required to retain information by other regulations? For example, required to retain payments or 1099 details. You're muted again, Tim.
I thought Aaron was taking that, excuse me. You know, there are going to be, again, I think if there is a pre-existing or a federal statute that governs information, then that governs by incorporation. I also think that if that is somebody else's information, you know, somebody's information, yeah, their remedies will be elsewhere. That is not new protection, that's existing protection for the consumer.
Question, so for clarity, I think we had this on one of the first couple of slides there. Does the let me try to reword this here. The response to a consumer's request to delete data or a privacy notice, does that apply to all companies or only those that process the data of 100,000 Iowans, those first couple qualifiers?
The first couple of qualifiers is who and that's, you know, because the idea was to get at the largest, right? The ones who are from maybe multi-state or multinational, have a large platform. Or if you look at if you are dealing in information as a primary part of your business model, then it drops the number of individual Iowans whose data you have to process. So that was all purposeful. But yeah, that first sort really gets at a specific universe, which is that fall within that definition.
Right. So if you don't meet those couple of numbers there or fall into a covered industry, you can ignore all this, right?
Correct. And be prepared to know that. I mean, that's the thing. So, you know, I've never been a processor or a controller, but you know, the Attorney General's office will get inquiries from those who are not covered by the statute. You might have to be able to say, here's why I'm not covered by that statute. Here's what I'm processing, you know, and here's how much revenue is coming from the data processing.
Right.
And Tim, I'll use that to kind of dovetail into this last question here that, you know, Iowa Technology Systems asked, as a small IT company, what can I do to support and raise awareness on the issue? I would think of it this way. There are carve-outs, and particularly for a small IT company, where it is less about understanding the regulations themselves and more about figuring out who is and is not included in this. Because you know, they mentioned the 100,000 records here, or 100,000 companies. That's a fairly large organization for a small IT organization. That you're not talking about an accounting company with, you know, a husband and wife and a secretary, right? That's not going to be an organization that falls under this. I think my advice would be, if you're a smaller organization, to Tim's point, understanding how this doesn't apply to you and making sure that you have quickly the ability to respond and said, hey, this is not something that we only have 800 records. This isn't something that affects the clients that we serve. The other side of it is that if you do find that you have an organization that you're serving that meets one of these requirements, either through the size of their data footprint or just the nature of the data that they have, I think if they haven't taken steps to begin to build a risk management program, that's probably where you start. You know, and it doesn't have to be, you know, the multi-page program. You sit down and running through some of the materials that are available on NIST for small businesses is a great place to get started for building a security program that will comply with things like Iowa's model, GDPR, GLBA, CCPA, whatever the blend of regulatory frameworks that you need. But you can start small. If this isn't a thing that only Wellmark is going to be able to respond to, right? And the carve outs are big enough that frankly, most small organizations aren't going to be really heavily impacted by this regulation, this specific regulation. I hope that helps.
Any last questions from the group? We'll leave it open here for just a minute. Time for Tim or Aaron, any final comments from you or recommendations you might have?
I would just, first of all, for any of the TAI members on this call, I want to thank you for your advocacy, your interest. I know there are some board members on this call. I recognize that from the participant list, people who were actively engaged throughout these last few years. The help, that is hard to measure exactly how valuable that is, but it's highly valuable to hear from real Iowa employers and companies about impact and importance. I would say if you are from another state and on this call and you have a similar organization like the Technology Association, although I'm sorry, probably can't be as good, but I'm a little biased. I would urge you to start talking to that organization or a business group or a chamber group to talk about, have you seen this Iowa model? It's the sixth, state in the nation. This is something that we should really look into, because the more organic, and in our case, it was entirely organic. The more organic it is, the better. And that's got to be true. And I've only worked in Iowa and Washington, D.C., but I have a hard time believing that's not true anywhere. So with that, I really appreciate the time and your attention, and I look forward to seeing you all or meeting you down the road someday. Thanks, Molly.
Thanks, Molly. Same here. Really appreciate the opportunity to participate. It's been an honor to lead the legislative committee for the Technology Association. We've done some really great things, but there's more to come. There are plenty of opportunities for us to help protect one another and ourselves. And I think that this legislation is reflective of the people that it came from. We're Iowans, so we want it clear. We want it to make sense. We don't want to spend the rest of our lives talking about it. So I think that this legislation makes a lot of sense, and that's hopefully part of the reason it's being considered for at least a starting point for the federal legislation. It's an opportunity for us to play on a fairly large stage. So Molly and TAI, it's been a pleasure helping this out, and looking forward to supporting organizations that need help with this down the road.
Well, I couldn't said it better myself. Thank you both so much for taking the lead on this and helping to clarify what this bill has done, not to mention all of your work the last 2 years and getting us to this point. For everyone who's joined us today, the guys here have both said it multiple